My name is Gary Strauss, and the case that I chose to discuss for the Week 6 case study assignment is Taylor versus Wake Forest University from Chapter 5 of our textbook, Case Studies in Sport Law. It is a case about contract law. A quick summary of the case. Greg Taylor was recruited by Wake Forest to play football. George Taylor, his father, and Greg Taylor submitted an Atlantic Coast Conference application for a football grant and aid or a scholarship, which was accepted by the university. He enrolled and became a student athlete at Wake Forest. At the end of his first semester, he had a 1.0 grade point average, which was below Wake Forest's required minimum GPA of 1.35 for freshmen. Greg decided to forego spring practices until his grades improved. He raised his GPA to 1.9, so he regained his eligibility at the end of his spring semester. However, he still decided not to play football anymore. Wake Forest notified Greg Taylor they were going to terminate his scholarship effective at the end of his sophomore year. Greg stayed at Wake Forest and earned an undergraduate degree. George and Greg Taylor filed a suit against Wake Forest to recoup their expenses from Greg's final 2 years of school. Wake Forest ended up winning a summary judgment, and the plaintiffs appealed. Some key facts from the Atlantic Coast Conference application for the football grant and aid or scholarship. The grant would be for 4 years, provided Greg Taylor conducted himself in accordance with the rules of the ACC, the NCAA, and Wake Forest University. He agreed to remain eligible under both the conference and Wake Forest rules. If he was injured while playing football and under a coach's supervision, the grant or scholarship would be honored. All medical expenses would be paid by the athletic department. If the grant is approved, it is for both academic and athletic achievement and is not considered employment in any manner. Some key facts of some of the NCAA rules that were in effect at the time of the agreement between the Taylors and Wake Forest. The institution, in this case Wake Forest, cannot cancel aid based on the skills of a student athlete or his contributions to the team's success. The institution cannot cancel aid because of an injury sustained by the student athlete which keeps him from playing. The institution cannot cancel aid for any other athletic reasons. However, aid may be canceled if the recipient voluntarily renders himself ineligible or commits fraud on the application or commits an act of misconduct that warrants a substantial disciplinary penalty. Aid can only be canceled if the regular disciplinary and/or scholarship awards authorities oversee the action and the student has had an opportunity for a hearing on the matter, and that such action is applicable to the general student body population. The timeline. In December of 1965, Wake Forest began recruiting Greg Taylor. In May of 1967, Greg and his father George submitted an application, an ACC application to receive grant and aid or scholarship for football. In the fall of 67, Greg Taylor enrolled at Wake Forest. December of 67, he was ruled academically ineligible because he had a 1.0 GPA, which did not meet the 1.35 freshman requirement. February of 1968, he notified the coach that he would skip spring practices until he improved his grades. In the second semester, he earned a 1.9 GPA, which meant he regained his academic eligibility. Despite this, he chose not to play football in the fall of 1968. In the fall of 1968, he earned a 2.4 GPA, but continued his refusal to play football. May 1st of 1969, Wake Forest notified Greg Taylor of a hearing, which would take place on May 14th. The hearing would be before the Faculty Athletic Committee to determine if his scholarship would be terminated. On May 14th, he was notified at the hearing that the committee would recommend to the scholarship committee that his scholarship be terminated for his failure to play football. July 10th, 1969, his scholarship was revoked effective immediately. In June of 1971, he earned an undergraduate degree, but he had accrued $5,500 in expenses during his last 2 years. George and Greg Taylor filed a lawsuit against Wake Forest University for the reimbursement of expenses in the amount of $5,500. The defendant, Wake Forest University, moved for a summary judgment. They based it on Rule 56 of the Rules of Civil Procedure on the grounds that there was no genuine issue to a material fact and that the defendant was entitled to judgment as a matter of law. The motion was allowed and the plaintiffs appealed the decision. In the appeal, the plaintiffs argued that there was a genuine issue to a material fact. They thought that a jury should decide whether or not Greg Taylor acted within reason and in good faith when he refused to continue his football career at Wake Forest when this participation interfered with reasonable academic progress. The Taylor's position depends on their contract with Wake Forest. George Taylor, Greg's father, contends that there was an oral agreement with the representative from Wake Forest that if the athletic participation interfered with academic achievement, Greg could stop participating in football for a short time or permanently to facilitate reasonable academic progress. He also contended that the plaintiffs alone would decide what constitutes reasonable academic progress. The defendants countered their argument was that the scholarship application turned in by Greg Taylor stated that he had agreed to maintain athletic eligibility according to both the Atlantic Coast Conference and Wake Forest University rules. The defendant also contended that both the father and the son knew the application was for football grant and aid or a scholarship, and it was awarded for both academic and athletic achievement. They also argued that it would have been a one-sided contract if the plaintiff was the sole decider of reasonable academic progress. And by accepting the scholarship, Greg Taylor was agreeing to remain eligible both academically and physically. This required him to maintain the required GPA as well as attending and participating in football practices. When he declined to continue his football career without incurring an injury or giving any other excuse other than to devote more time to his studies, he was breaking the contractual agreement. The Court of Appeals did not agree with the plaintiff's assertion that they had an oral agreement with the representative from Wake Forest. By failing to continue his football career despite being academically eligible and without suffering any type of injury, he was not in compliance with his contractual obligations. The record disclosed that Wake Forest University fully complied with their end of the contract, and Greg Taylor failed to uphold his part of the contract. The court found no genuine issue as to any material fact, and that summary judgment was proper and no errors were found. The appellate court affirmed the lower court's decision of summary judgment for the defendant. There are some implications for an athletic administrator. You need to make sure that you adhere to all existing contracts. It is important to know and understand all bylaws and rules that govern your institution. And you need to know and understand all eligibility standards and what is expected of each athlete who participates in any of the activities that you oversee. You also need to make sure that any actions taken are based on policies that are applicable to all other students at your institution. And lastly, you need to make sure that due process is followed in all situations. This concludes the presentation.